right, so here we go. It's exactly 2:45 on the dot. So we're going to begin with, this is the 16, this is the last workshop of the day for my track anyway, just in case you're wondering, are you in the right presentation? This is the 16.22, the mental health law that everyone should know about, that everyone in the state of Texas, I think, should know about. So I'm going to begin with a few introductions. I am Judge Yolanda Huff. If you've been following my track all day, I've been here all day. So I preside over County Court 12 and the Mental Health Court. And who I have on the panel, I'm the moderator for this panel today. I have Renee Munoz here, and I'll let each one introduce themselves, give a few moments to introduce themselves. I have Christy Taylor and Laura Duque. So we'll begin with Renee. Renee, introduce yourself. You guys got the microphone.
Yes, hi, good afternoon. My name is Rene Munoz. I'm a felony public defender specializing in mental health issues within the Bexar County Public Defender's Office. It's a pleasure to be here.
Good afternoon, Christy Taylor, the Executive Director of the Texas Judicial Commission on Mental Health. We are in about our 7th year of operation. So if you haven't been familiar with our work, I'm happy to talk to you about it after.
Hi, I'm Laura Duque. I am with Bexar County Pretrial Services. We monitor individuals that are released on bond and have a condition to report by the judge to our office.
Thank you, guys. Okay, so I'm going to talk a little bit about the Judicial Commission on Mental Health. Now, I said in the last presentation that I ran for judge in 2018. In 2019, January 1, I was sworn in. I'm off and running. So that very first year, I went to the Mental Health Summit that the Judicial Commission on Mental Health puts on. And that year was the one that was in San Marcos. That was the year it was, okay? Now, I'm telling you this backstory because that is the year that I found out about the 1622 law. Now, at this time, I'd already been a defense attorney for 22 years. I'm on my first year on the bench, and I'm just now being explained that, did you know that there was a law out there that's called the 1622 law that deals with mental health? Like, my mind was blown because I'd seen in the files, I'm on the bench and I'm dealing with cases every day. There would be this red envelope occasionally in files. And I looked at the envelope, it was sealed, and I just kind of pushed it aside. I didn't know what to do. It wasn't for me. I didn't do anything with that envelope. But that was the 1622 report. So I go to this mental health summit with the Judicial Commission on Mental Health. And by the way, you guys should really go to that website. The Judicial Commission on Mental Health, that Christy Taylor, she's the director of that. She's down here very busy. She's a very busy lady, but she's down here presenting with us. And that commission was created in 2018 by the Supreme Court and the Criminal Court of Appeals, right? Yeah, a joint venture that created this Judicial Commission on Mental Health. And what it is a commission that deals with, they invite judges, mental health advocates all over the state of Texas to be commissioners and then collaborators. And they meet quarterly. And the whole discussion is about, the whole topic, the whole presentation, the whole shebang is about the judiciary in the state of Texas and mental health. So if you guys are not aware that commission exists, and they put on a free mental health summit every year, and it's one coming up in October. It's coming. It's free. It's every year. The conference is free. And I've been attending it every year since I've been a judge. So I would invite you guys to go find that website and read up on the Judicial Commission on Mental Health. Because if people don't think Texas is doing enough about mental health, really educate yourself about what the state of Texas is doing in the way of mental health in the judiciary. So anyway, I'm at this conference. What they did at the conference was they broke all of the counties down into groups, and we were put in rooms, and then they sent someone in the room and said, we gave you guys a little bit of grant money. What are you doing with that money? And we were like, Bexar County, we were like, because I didn't know. And then they were like, well, I mean, my mind was blown because I'm saying, so that's what those red files are about? I mean, after that conference, I went back to Bexar County. I was on the ball. I formed a committee for Bexar County. That committee was about, Laura, what would you say, about 60, 70 people? And we started meeting monthly. I'm like, well, let me educate myself about this new law I just learned about, the 1622 law. So it is a law that says that anyone in the state of Texas that gets arrested for a Class B or higher misdemeanor, you have to be given a mental health interview to see if any mental health IDD presents. And it's just a one-page piece of paper. It is not an assessment. It is really called a mental health report. And you're the person that does it. That person's entitled to see that report about themselves. Once that report is generated, it has many uses. Like it is given to the judge, the defense attorney, the prosecutors, probation. I think even pretrial now gets it. Right? And it is to see, because we get so many. I think that the statistics may be that I know it's well over 50% of the people that are arrested present with some kind of mental health illness. It may even be up to 60% by now. So that report is very necessary, because that report mainly is going to help the defense attorney and how they choose to defend their client. And I'll tell them, when I was educating myself about this law, and I knew that report would be in a file, I would see that red envelope, the defense attorney would come before me and I would say, were you aware that your client has a 1622 report? And most of the time they didn't, because no one else in the county knew about this law either. This law was enacted in 1993. That's how long it's been around. But we just weren't being educated about it. So what I was trying to do by creating that we called it the 1622 committee here in Bexar County, I was just trying to educate the judges and the defense attorneys that it was there, and trying to streamline this law and how we get it to defense attorneys, that making sure that once they got appointed or started to represent somebody, that report would be sent along with the discovery, that they would know that report was there. Because oftentimes the defendant is not going to say, I have a mental health illness, or I did a report. They don't even know a lot of times that a report was generated. They don't remember being asked these questions. But I was trying to make sure that the defense attorney got that knew that report was there, and that they could read it and then they could deal with it, because that report is so useful. The defense attorney really legally has the right to come to me as judge and say, my client has a 1622 report done, judge, and mental health issues present. Could you lower the bond? And Renee is going to talk more about the mental health bond that 1622 is used for, to get people with mental health illnesses out of jail, right? So that's what that law is about. And I thought about, when I was making the track, that I really want to make one of the presentations about this law. That, like, let me see a show of hands of people that knew that this law existed in Texas. I see 1, 2 here. So the rest of y'all were not aware that we had a law in Texas that stated this, right? That's how I felt too. Even as a defense attorney, even other judges, many lawyers don't know, right? So let me get this, right? So I'm going to start off with Christy. Being the director of the Judicial Commission on Mental Health, tell us a bit about the Judicial Commission on Mental Health, and how did it come about, and you're being the director, and are you the first director, the only director? Okay, go ahead, Christy, you got the microphone.
Well, thank you, Judge. I'm going to take you on the road with me. She is a fan. But I do want to thank Judge Huff. I don't know, are most of you family members, advocates, no, professionals in the system? Okay.
Lawyers.
All right. So we know that there are evidentiary rules in place to make the system fair, but a lot of times that leads to the judges being very inaccessible. They are in their black robe, up and on the bench, and they're not here. They're not here talking to us and educating and passionate about it. And so Judge Huff is one of those judges that's changing the culture of that, and really, really appreciate it. So in 2018, like Judge said, we started this Judicial Commission on Mental Health, and because of part of that perception of inaccessibility, that we realized that we need specialized training. We needed judges to not become psychiatrists, but they need to know enough to know when they need help, that they need to know about these laws that no one knows about, that they have a lot of demands on them, overcrowded dockets, and that the lack of coordination is a barrier in and of itself. And the way I think about it is, people do not enter the civil commitment process, they do not enter jail. All of those processes are gate-kept, I guess, by judges. So we can take the siloed approach and say, well, mental health isn't what I went to law school for, or we can solve problems by working together. So the two highest courts in Texas sat together. That's a photo of them. They had never sat together before, y'all. And so this was in 2018 in January. We had testimony from experts from all around the state. Oh, let me move I've got two places to move it. Yeah. They sat together and heard testimony from professionals in your shoes about the frustrations of the legal system serving as a barrier. So they decided they wanted to create a permanent commission, not just a task force that came and went. And they put funding behind it, and we have a staff. It's very small, but we are a permanent judicial commission on mental health. We are housed in the Supreme Court building with the Court of Criminal Appeals as well. And it was very unusual. We were clearly the first state in the country to have something like this. We've had other states come to us now and try to create this. And so it was monumental. Some of the things that they heard about when they were listening to that testimony was the people, the bottom line. That we can get lost in the laws that we've drafted and different opinions about how those should work out. But what they were surprised by is they heard the stories of the humans that were affected. We had a mom testify about her daughter with intellectual disability and how she had been treated when she brought claims of a sexual assault case, how she was dismissed, and that the perpetrator was still a football hero. We had individuals who'd been through the system themselves talk about what it's like to be on the other side. Actually, Angel Carroll, if any of you know her, she was one of the stars. We had a NAMI hero, Adrienne Kennedy, who is on the national board, talk about her trials and tribulations through the judicial system, what helped, what hurt, and but again, brought it back to the people this is affecting. So it's a somber beginning, but this is what we're talking about. This is a list of names of people who died in our Texas jails, pre-trial mostly, waiting for our courts to respond in a better way than they did. And they are brothers and mothers and fathers and from all different sorts of lack of knowledge or implementation. But I do want to start with this is what we brought to the high court judges to say that this is why we're paying attention. And if you know anything about the court systems at the highest level, you know, they're reading about very legal matters. They're not reading about the facts of the case anymore. And so it was quite emotional and a bit of an awakening for them. But we have had their support fully, and we were able to go out and recruit judges, like Judge Huff has served on the commission, so they can inform what's happening in the courtrooms, what the limitations are, and what their needs are.
Next, you're up next, Renee. Okay. So, well, I guess Christy is. Why is the Judicial Commission on Mental Health encouraging that we all learn and use 16.22? Again for Renee. Again for Christy.
Okay. All right, I'll answer that one. So this is the sequential intercept model. The reason that we are trying to educate people about the 1622 law is that it is earlier in the process. A lot of times when courts get involved, it is on the later end of this model. Are most of you familiar with this? This is just a way that we organize interventions. It is how people with mental illness or intellectual disability move throughout the criminal justice system. It was created about 20 years ago by Policy Research Associates, and then our commission has taken a Texas spin on it to make it match our process a little better. But it definitely displays the aspect of how this can be a loop and how we want to intervene as soon as possible. So the intent behind 1622, it's criminal Code of Criminal Procedure 1622, is early intervention. At this, early identification of individuals with mental illness or intellectual disability, and then not just identification, right? But then what do we do with that? Are we notifying the people that need to know? Are we letting them slip through the cracks to where they get to the point where they're on death row and for the first time we're talking about their intellectual disability? Or are we identifying this the minute that they're crossing over into our systems? So this is the reason that this law was drafted. Judge said, 30 years ago. But recently, after the passing of Sandra Bland, there were revisions made to the law to make sure that, let me see, there. Oh, it's one of these fancy ones. That to make sure that we were paying attention in the right way. So I know you're all familiar with Sandra Bland, but looking back on that, 1622 might have prevented her death. If the portions of the law that have to do with law enforcement diverting rather than incarcerating someone, that might have stopped her from ever being incarcerated. Or at the very least, if she had been identified as having mental illness, there should have been every 15-minute checks on her while she was in jail rather than the normal hourly check. And the facts of her case state that she was checked at 7:34 a.m. and then not again until 9:07 when she had been found to pass from suicide. So these are the real life effects of this, and it's horrible that it takes a tragedy for us to find out about this law, but I know that I and many other people were not going to let this pass after something like this. We are going to find out more and put it to use. So I just wanted to say, whenever I think about the grave side of what we do, I also have to think about the heroes in this. That if you think about how many times you've seen one extra phone call that you've made, one extra step that you have taken, how it's changed lives, that is the attitude we have to go into with this kind of work. Thanks, Judge.
Right. Thank you. Thank you. All right. So, Renee, what, in your opinion, is the greatest hurdle in representing those diagnosed with mental illnesses within the legal system?
Thank you, Judge Huff. Great question. There are obviously a lot of obstacles and challenges that can present itself when dealing with the mentally ill, intellectual deficient individuals, as well as poverty-stricken, homeless individuals as well. Communication can sometimes be difficult depending on their living situation. Do we know they've been charged? Say hypothetically they've been let out. They have a future court date. Do we know where they're at in between then? Have we made contact? If we believe they're possibly at Haven for Hope, maybe contact them, have a message sent with our information. My office, the Bexar County Public Defender's Office, which I'm glad to be a part of, we do have a number of social workers, investigators, as well as other attorneys that can help us on that end in terms of bridging the gap so they can come forward and be made aware of what they need to do to be successful to address the charge, because we all know that if someone doesn't address the charge, it's eventually going to catch up with them, maybe even resulting in additional charges being brought. So we definitely want to create an atmosphere of being more proactive rather than reactive to situations. Another obstacle, obviously, as a lot of you have heard throughout these presentations of the one before, is the general lack of funding for mental health resources, inpatient facilities, outpatient facilities. The continuing population of sanatories continuing to grow. However, the mental health resources are not keeping up with that population. As a matter of fact, Texas, in comparison to a lot of the other states, do not have significant mental health expenditures. We're one of the biggest states, however, we are seemingly at the bottom in terms of paying for resources for these mental health people. So in terms of public defenders, I know that I've gone to multiple public defender conferences. I've gone to Rise Recovery conferences, as well as specialty court conferences. And I know that that's a common theme across all those issues that we're having, is that a lot of the times we're having to get creative in dealing with these people with mental health illnesses We're having to piecemeal their treatment. We're having to give the best advice moving forward. However, there just is just not enough resources a lot of the times to have a secure fit in there. So that's something that, as a community, I believe that we can all work towards and bringing towards these issues to our congressmen, to our senators, to our elected officials, that there is a great need for these resources to help out the most vulnerable in our society. And obviously, the last portion, I believe, it requires a great deal of patience on the defense attorney practitioner. I myself am fortunate enough to work with the Bexar County Public Defender's Office. I am a county employee. I don't have my own law office, so that's something that's differentiated from some of the other attorneys that are court appointed. They're private. Sometimes they're called public defenders. I don't call them public defenders. I call them court appointed because I believe that what we do as public defenders is a little bit different in terms of niche. Myself, I deal with only felony mental health cases. Those are 95% approximately of my cases. So a great number of the 1622s are coming into me. Every time I get a case, it's the first thing I see, which is a great help to me. So I do thank you for that question, Judge Huff. Hope I was able to answer some of those aspects.
Well, Renee, how do you find a balance between advocating for your clients in legal proceedings versus the potential need for them to receive treatment when they have declined the avenue of resources?
That's an excellent question, Judge Huff. In a lot of things I strive to do, I strive for balance. I strive to seek understanding because then that's going to allow me to see where that person is coming from. It's an empathetic kind of mindset. It's not one that I feel if I had my own law office and I was struggling to make rent and I was struggling to go from county to county and keep the lights on, I would not have the sufficient time to do. But a lot of these people do deserve patience. A lot of their issues are complex. A lot of them are just not a first kind of hearing, plea in, plea done, sayonara, see you later. There's a good chance that that person's going to re-enter the criminal justice system, and my fear is have another charge or have something more significant where they're maybe looking at potential prison time. They're looking at potential inpatient treatment. They're looking at a lot of extended jail time. That if we got a handle on the issue and we saw the smoke and we got a handle on that, it was not going to turn into a big fire. So I try to approach my clients with patience. Obviously, I've never been homeless, fortunately. I can only empathize and sympathize with a lot of the things that these clients are going through. And even if I've had a stressful, long day, I try to take a deep breath and realize that this is someone's sister, this is someone's brother, this is possibly someone's mother, father, uncle, that they care about them and they want them to have due process under the law. So expounding upon that question that Judge Huff indicated, what if hypothetically the person said, I don't want treatment, I just want trial, I want my day in court, I'll take the jail time, I just don't want any treatment. Well, at that point, I tried to stress the importance of getting treatment if I believe that they need it, or other people have shown interest or have put forth the fact that they may need treatment. I try to explain the avenues and the options and the possible advantages versus the consequences of that. You do well, you work a program, you get some drug treatment, the case is dismissed. It's a win-win for society, it's a win-win for the client, it's a win-win for me, so I don't have to see them re-enter into the process. So I think that listening to them, one, being patient, letting them know about their options, and obviously, if they just want to forego all treatment options and assert their constitutional right to trial, I will do that for them as well, because I am constitutionally bound under the Constitution to provide them due process rights. Now, if I feel that we can get to the root cause of their issue and not have them continuously cycle in and out of the criminal justice system, I'm obviously going to be a proponent of that, because there are some systematic things going on that a lot of the clientele that I represent are people that have numerous charges. There are people that have 8, 10 pages of criminal history, 25, 30 plus arrests. And it's not incidental that those people are indigent. Those people are having a public defender represent them because they've been institutionalized, they've become a product of that system. And the goal is to identify, treat the root cause, to not have them recycle in and out of the criminal justice system.
Thank you, Renee. Thank you for that. That's a great answer. So, Laura, can you briefly walk me through a high-level overview of the steps of the 1622 process? I think we have some slides up here too.
Thank you, Judge. So the first step of the 1622 process is the police intervention, detention, and arrest of an individual. Law enforcement must divert when appropriate, so that's what we would hope, that there would be good faith effort in diverting instead of arresting the individual. Officers have the discretion in responding to the situation, and if the community is involved, whether they have mental health or IDD. Here in Bexar County, I know there are multiple programs for individuals that for diversion instead of being arrested, but in the event that the individual is arrested, that is step one, the arrival at the jail. Law enforcement drops off the defendant, tells the jailers anything that may be a sign or a symptom of mental health or IDD. They tell the judge within 12 hours of discovering credible information that this person may have mental health or IDD. And how do we know? Initial identification information can come from any source of credible information. And also, what are the signs and symptoms that they're looking for? So step two is the identification of individuals with suspected of mental illness. Here in Bexar County, it happens at our Justice Intake Annex Center. And overall, it's wherever the individual is being taken to, where they're going to be arrested at. Observations can come from multiple departments, law enforcement, jail staff, magistrate judge, the public defender, pretrial services, whoever may see that type of observation. So the screening, this is one of the screenings that's done, the TCJS screening, which is part of the screening for the 1622. It's a questionnaire that is given to the individual, and then that's where the report is built off of. That the judge was speaking of earlier. So the magistrate must make a reasonable cause determination, and these are the qualifications. So they review the notifications from the jailers, any documents attached to the notifications, review the charges, criminal history, meets with the defendant, and then the magistrate decides whether there is reasonable cause to believe the defendant has mental illness or IDD. So if no, then no further action is needed. If yes, then the magistrate will find reasonable cause and shall order a qualified mental professional to interview the individual and complete the 1622 report. A few exceptions: if the defendant had a 16.22 done within the last year, and then if the defendant is out of custody, and if it's only a Class C misdemeanor. So those are all exceptions to the 1622. Exceptions that may apply: the magistrate clerks to see if a prior 1622 was completed within the year. If yes, the magistrate is allowed to use that report. If no, then the magistrate judge shall order the 1622 interview. The magistrate checks to see if the defendant is still in custody. If not, then they order the 1622 interview. And if they are still in custody, then the magistrate judge shall order the 1622 interview. In Bexar County, this is all done at magistration. So here locally, if the interview is ordered, then it's all done inside the magistration process. So after that, the magistrate checks the charge. If it's only arrested on a Class C, then ordering a 1622 interview is discretionary, and then arrested on the charge greater than a Class C shall order a 1622 interview. So the magistrate orders the local mental health authority to interview the defendant and write the report. And this is just going to go basically over the interview in general, not per se for Bexar County. So the local mental health authority conducts the interview, and then the report is then given to the magistrate after the report is done. What does the local mental health authority do with the report? They send the report to the magistrate judge, and then that's the communication between the magistrate judge and the court. So the communication between the courts and local mental authority about the defendant for purposes of the continuity of care and services for the defendant.
information sharing. Very important part right here, information sharing. So, Laura, we discussed earlier that many counties have not been able to set up their 1622 process because, Texas is big. We have 254 counties. And a lot of them, and the Judicial Commission on Mental Health, this commission has only been in existence since 2018. Christy, how many counties you think that do not have this process set up? Any idea?
Maybe 244?
Have it set up?
Do not.
Oh, okay. So there, you're saying that only about 19 have it set up? Oh boy. And remember, this is a 1993 law, okay? So Laura, we discussed earlier about this. Can you tell us a little bit about how Bexar County came into compliance with this law through collaboration? And you were there on that 1622, but I knew you guys were doing things before I convened that committee.
Correct. Before the committee, so through Bexar County, they collaborated with multiple departments within, the community, the courts, the judges, the sheriff's office. So the 1622 is done at the Justice Intake System Annex right now. But to get this started, there had to be multiple departments that collaborated and still collaborate. So inside the Justice Center is the Sheriff's Office, who is booking the individual, and then the magistrate judges, of course, the clerks. Bexar County also works with the Public Defender's Office and very closely in regards to these individuals to see if there is a diversion option. Then with the Center for Healthcare Services, who is greatly appreciated and who is doing the actual report of these individuals for the collaboration for the 1622, then if the individual is suspected and ordered, then there is the diversion option for individuals that can be diverted outside of jail, whether they be released on a bond or they will be released on a mental health bond with some type of diversion process to be able to coordinate between all the departments and then make sure that individual or try to prevent that individual from coming back into the system.
So just so you know, this law is mandatory. Like they shall, like the counties are supposed to be doing this because it is, when you see the report, it is literally just a single sheet of paper. And I've read through many now that I've been on the bench, and it really is just a heads up like that. So everybody out there, if you've ever been arrested since 1993, in Bexar County, you've had these questions asked. May not remember it, but that report has been done on you. We know that report is in your file. As a matter of fact, Bexar County just started a new system called Odyssey. And with the Odyssey system, we don't believe in that report doesn't even have to go into the file anymore. It just says right on the docket sheet 1622. And then that's a heads up to me as judge. Oh, a report has been done on this person. And I'll see those sprinkled throughout my docket sheets every morning, right? So what the awesome task that Christy is tasked with doing is getting these other counties up and running, that they need to get on the same page because, again, this is about what Judge Kazin said in the previous presentation. This is life or death, like what happened to Sandra Bland. These things need to be implemented into the jails to save lives because when we're arresting individuals, and by the way, a Class B is like a DWI, a theft, assault. A Class C is a ticket. So we're not, they're rarely probably doing this for tickets. So I'm a county court judge. I deal with these DWIs and theft cases, assault cases. That's anything over a B that this report must. In the law, I tried to really educate myself on this law. The commissioner's court is mandated to pay for this. Now, whether they're making, I know some of the counties in Texas are really poor. They can't. Just like Laura said, this is a big implementation of something in your judiciary. But what is a better time than now? What, are you going to wait 10 more years on the road to do it? Like all these counties, they need to do this now to get on board to start this. Now, you're really talking about saving lives. I want to ask the question. How many here know who our local mental health authority is? Who? The Center for Healthcare Services. All the 254 counties in the state of Texas have a local mental health authority. Some counties share one, like we have Blue Bonnet. I think that's out there in Kerr County. What is Travis County's called? So Every county in the state of Texas has a local mental health authority. Every county. So when that acronym was up there, I saw those acronyms and my mind was clicking like, I wonder does the audience know? So for Bexar County, the Center for Healthcare Services is our local mental health authority. All right. So it's just a little side note there, guys. Get back on track now. All right. So, Renee, as a defense attorney, how would you like for the magistrate to use the report? Offer the mental health bond, things. How would you like to see this report being used?
Yes, Judge Huff. Regarding the 1622 report, like Judge Huff stated, it is a one-page report. It does give a heads up to certain stakeholders, the public defender, the magistrate judge that's on duty, for them to maybe consider a different bond. Specifically, Texas Code of Criminal Procedure, Article 17.032. Now, that's a PR bond statute for mental illness or intellectual disability, IDD. PR bond stands for personal recognizance. It's a free bond. Those are the good ones. Those are the ones that a lot of people are vying for. And not incidentally enough, they're the ones that need it most because they're indigent, they're poor. Sometimes sometimes the magistrate judges or certain county court judges will set a $1 bond. That might as well be $1 million to a homeless person. So these PR bonds do serve a great purpose into diverting people from just sitting in jail pending potential indictment or pending their misdemeanor court date to get a hold on their services. So the judge can consider, in certain instances, issuing a PR bond with the mental health aspect. Usually for PR bonds, judges will look to the criminal history. If it's quite extensive, they may shy away from that because there may be a likelihood of them not showing up to court in the future. They'll also look to the facts surrounding the arrest, why they're actually there to begin with. And if it's something of egregious, violent nature, they may hold off on that case for potentially the community safety and also safety of that person as well. However, in certain instances, once that mental health bond is granted with PR bond, I'm sure Laura can speak a little bit more in depth about this, but it allows that communication and those services with Center for Healthcare Services, with Haven for Hope, to get that person set up with services, evaluated as soon as possible. And if that's done and they're receiving treatment, it does give the defense attorney a lot more to work with in terms of mitigation, in terms of possibly having a reduced sentence or possibly just having the cases dismissed outright. So I'm very thankful for the 1622 process. I'm very thankful for Christy here in helping initiate that, and also for pretrial services in allowing that avenue for them to get the much needed help that they need.
I'm going to go off a little off script here. Laura, could you tell the audience some of the diversions that pretrial has? Like once you get that report, and I know Bexar County has a lot of them.
So at pretrial services, we work with the individuals once the individual is released on bond, whether it be a personal recognizance bond or a commercial bond. If the individual has some type of condition that they're ordered to report to pretrial services, we still supervise those individuals. So we work with multiple agencies, the Center for Healthcare, #1 here in Bexar County, and our caseload of individuals that we manage. The Center for Healthcare Services has multiple programs that we try to have these individuals get into so they can get the services they need, and of course to show up for court when they're required to. We also work with CrossPoint, who offers transitional housing and mental health services, and Lifetime Recovery, which is also a program that we have for residential and outpatient substance abuse treatment, which sometimes, of course, it can be co-occurring diagnoses. So the Center for Healthcare Services can help with the individuals for the mental health treatment, and then Lifetime Recovery for their substance use.
That's the diversion. Like, so the law says that when possible, divert the person from jail. And actually, on the outset, the officer is really mandated to, when possible, don't arrest this person. Take this person to maybe something like that. That's at the top of that law, that when possible, think of other options besides going to jail. That is actually the law, and we can put that back up there, and maybe that's the law, right? And I was talking about what I was asking Laura was, yeah, diverting people away from always being in the judiciary, even getting to me, especially courts, diverting them on the outset. Yeah, so that's it. Officers have considerable discretion in responding to a situation in the community involving a person that may be engaged in a criminal conduct, experiencing a mental health. They are really obligated and mandated to divert that person away. They have a lot of discretion. Are we going to enter, like besides drawing weapons or anything, there's so much discretion that that officer, and that's why I think it's so critical that getting the officers trained in mental health in all of our communities, all across Texas, all across America, if you really want to be honest about it. That when the officers are called and they get to the scene, and that those magic words, mental illness, or say it, that the officer can use this discretion in so many ways. Right. So, Christy, what should the trial court do with the report? How does this help a defendant with mental illness, the 1622 report?
Yeah, Judge, the main points of this law, like we said, are to make sure that we're identifying someone and we're connecting them. But ultimately, we want to make sure we're communicating this throughout the case. Oh, let me go one more back. There it is. So another part of the law is that the magistrate is supposed to send this report to defense counsel, prosecutor, the trial court, the sheriff, and the bond office, or pretrial services. The problem is that, we write these laws in a policy setting that isn't in the real world sometimes, and I'm guilty of it. I'm one of those people helping write the policy. And there was a missing piece to this, that the law didn't exactly explain how the magistrate was supposed to do that. So I think this is what has stopped a lot of the counties from continuing with this, is that we're disconnected. We have a magistrate maybe filling out the report, but they have to create a proactive process to hold that report, because you don't have a trial court yet at magistration. And I think when the law was being developed, we didn't think about all of those pieces. And so I want to backtrack a little when I said, not very many counties are doing this, because I want to defend my small counties that are doing this in pieces, right? You have champions in every county that are doing the right thing, that are talking to people, that are sharing information. They may just not be doing it formally. And doing the report and following 1622 like this in a formal way creates accountability. It creates a trail. It creates history. When we have people who are unhoused that don't have paperwork and we don't have a lot of information on them, we are then creating a court file. And so Bexar County was, I think, the first large county to create a completely different process, because their county clerk was paper and your district clerk, right, was electronic. So you had to create two different systems to track this report in different ways. So I do want to say that it's not as easy as it sounds. We passed these unfunded mandates, right, that there was no funding to go with this. It was just like, counties, this is what you should be doing, and this will help. And so I think a lot of people are doing it in spirit, but we are trying to go back and formalize that, and let's do it the right way. And Bear has definitely been a leader in that.
So I think we have about, let's see, we have about 15 minutes left. Are there any questions? Anyone want to write down a question and bring it up? Any questions? Here we go, right here. Okay, so here we go. Let's see. So why do so few defense attorneys know about 1622 mental health law? What do you think, Christy?
I'll let Renee, but I think because I don't think the counties are following the formal process, and so then it's not expected. I know you're a defense attorney.
Yeah.
Starting to know about it.
Yeah.
Attorneys in Judge Huff's court definitely know, I'm sure at this point.
Definitely know.
Because Judge Huff has been instrumental in spreading the importance of this report and the fact that people need to know about it. Obviously, I'm exposed to it quite a bit because a lot of my clientele are mentally ill. With the new Odyssey system that has come about here, Tire Technologies here in Bexar County, now anybody can see the case status that's currently pending, and it will have a designation that says 1622 report. So that from a criminal defense standpoint, should spark interest in knowing that this person has issues that may need to incorporate into their case. They may need a little bit more communication. They may need resources and treatment. So I'm very fortunate to have the background and know what it means. I think that word is getting around through the private bar what that means, and we'll continue to spread the word, and continue to spread the word along with Judge Huff and others to just the private bar that sometimes they're, for whatever reason, not as in tune as to what certain things mean. But within the evidence, I will say this, as a defense attorney, when I request the evidence, the 1622 report is there, and it does have an indication that the person has a mental health illness. So if a defense attorney is worth their snuff and they're doing what they need to do, they will have that notice also again when reviewing the case for gearing up for their potential court setting or trial.
So I would have to say that I'll take a lot of blame for the judiciary. Like, I told you guys that I've been a judge now for 6 years. And when I got to the bench, it just seemed to me that why aren't we, the judiciary, telling people about the resources at the courthouse? Why do we make it so mysterious for everyone? And it's just not how I'm built. So as a new judge, I was like so different. Like, judges, fellow judges, we need to be out in the community telling folks about these resources, specialty courts, the 1622 law. And I think that so I was invited by Doug Beach to be a board member for NAMI. And I said to Doug one time, and I said, why don't y'all ever invite any of the judges out here to talk about things? And I have this theory to myself, I'd say, that maybe they don't think, no one before has ever said that they don't think that judges would want to or be open to going into the community to say these things. And so Doug was like, okay. And I said, well, I invited like 4 other specialty court judges, and we presented at a NAMI monthly meeting. Then I said, who else y'all should get out there? Y'all should get Sally Unkerfer out there to talk about competency. I had a list of names for them. And they were like, look, you know how complicated competency is? I swear to God, Sally could have talked for 6 hours. The questions just kept coming and coming and coming. Because I don't think that they knew that judges would be just willing to show up at a NAMI monthly meeting and talk about what we do. And it's the same thing with the specialty courts. Like, these programs have been around for years. Why so many few people know about them? Like, I really do get on my fellow judges. We have a duty as public servants and judges to educate the community about resources I take that very seriously. You're gonna see me, I'll present at least 2 or 3 times. My team knows. Jessica's over there in my court is, Josh, you gotta say no sometimes. So it's like, she tells me, I never refuse, you never say no. Because I just feel this urgency that we've wasted so much time. These programs have been up for 20 years, and so small percentage of Bexar County know about all these resources. And like I said earlier, you guys are all paying for them. These are tax-supported programs. I'm just trying to get my brethren on board with me that we need to be out in the community. And I was telling Doug, for the pathways, why don't you have any judiciary judges? And he says, okay, smarty pants, you're being voluntold to do the whole track. So here I am doing the whole track for the day. You want to complain? I'm like, I'm here. I love it. I love presenting. I love educating and telling you guys that these programs exist. Because to me, truly, knowledge is power. Knowledge is freedom. It's the more you know when you have these hurting families and the families just don't know where resources are. It's on the judiciary. It's on us. Even us telling the defense attorneys, like, I question every defense attorney that comes before me, did you know your client had a 1622 report? What? You want to read it? It doesn't violate HIPAA. You want to read it? I mean, I'm on them every time I see it. Like, they're knowing. If they're in my court, they're learning about it. Like, that board certified defense attorney, I don't know why he didn't know, but it has been a law forever. And I'm sure that if they got discovery from the state, that 1622 report, I would guarantee you that 1622 report, if it's in Bexar County, went along with that discovery. What do you think, Laura? What do you So few people know. Okay, let's see here. So what happens if someone is arrested but does not have their psychotropic medications with them? How do they get the medications they need in a timely manner? I say, Laura, you think that? Laura can answer that question.
At least here in Bexar County. So the University Health System is inside of our county jail here in Bexar County. So they are the responsible authority inside of the jail to provide those medications, the assessments, the evaluations. They have the doctors that are there that are supporting for the medications. And while they are inside a jail, it doesn't matter for how long, if they need it, the doctor will prescribe it there.
So, like in the mental health court, like I think one of my mental health team, I know Josh was here earlier. Like we will just call the jail and say this person is on this medication. We want, it's communicating, always communicating. Like somebody they get arrested, they're in the program and they get arrested for something else or whatever reason they're back in jail. The team is very concerned. They can't be in there without their medication. But that's very dangerous for them to go without their medication. So we make sure that we call. There's a protocol. There are people at the jail. They're just there for that. Okay. So another question is, what is the specific criteria questions used to determine if someone falls under the document? What are those questions, Christy? There are the questions that it's not that complicated.
Yeah, the magistrate judge makes a reasonable cause determination, and the openness of the law is that anyone can inform that. It can be the magistrate's own observation, it can be the jailer, and I think that it does nod towards more open communication from the family too, and allowing in that information that somebody else already has. And I'll tell you, Bexar County is also excellent that you have representation at magistration. And I don't know if you know how rare that is. I don't think that's happening in any other county in the state.
It's the public defenders. They're there.
Yeah, the public defenders are in
the jail.
In the jail from the earliest. And I had done civil law, and when I switched over to criminal a decade ago, I had all these conversations like, what do you mean there's a bond decision made and it's just the prosecutor and the judge and there's no representation for the defendant? That just didn't sound right. And it's one of those things that's just the way it's always been done. And so the fact that you guys are in there, that's huge.
And so, Laura or Christy, those four, because when I look at that 1622 report, I see about 4 questions that like that. Do you know those questions that are actually on that one page? I think that's what the questions used to determine if someone falls. Maybe that wasn't the question. Was that the question? Whoever sent that. What is the specific criteria questions used to determine? Was that question answered? Whoever sent that question? Yeah.
Yeah, there's a few questions that are on the assessment. Do you hear voices, or other people seem to hear that other people don't seem to hear? Do you currently believe someone can control your mind? Prior to the arrest, do you feel down or depressed? And then there's also the continuity of care screening that's done at least here in Bexar County. If the individual the officer will run a CCQ hit, which would be continuity of care. So if they've had treatment or mental health in any city in the state of Texas, then that information will come in the CCQ hit. So it does. That's another way that the individual is screened.
So Sally Unkelford, our awesome prosecutor, said the jail mental health number, if anybody wants to write this down, is 210-335-6271. That's the jail mental health. Like if you have a loved one that is arrested and you want to know did they have their medications? Can I deliver the medications? How can I deliver the medications? When you want to make sure that medication, there's a continuation of the medications, I think this is the number to call. I'll say it again, jail mental health, area code 210-335-6271. So I'll start with Renee. So is there anything else, I'm going to ask each one of you guys, that you want the audience to know about the 1622 law? So we have a few moments. We got about maybe 6 minutes, so 2 minutes each. We'll start with Renee. Is there anything that you want the audience to know about this law?
Just want the audience here in Bexar County to know how fortunate we are to have this law and to have the officials abiding by it at the jail. It is a great benefit, a lot that we heard from Christy that a lot of rural counties don't necessarily have. So we do have great coordination between pretrial services, the magistrate, our on-site public defenders that are there 24 hours a day, working shifts overnight at the jail. So they had that representation there, something that Christy made up that very proud of being a part of that office that spearheaded that and continues to be one of the only ones in the state that do that. But looking at the numerous issues that can go with mental health and IDD and the poverty-stricken, that here in Bexar County, I think we're moving definitely in the right direction to creating efficiencies and setting the standard of how these kind of cases should be dealt with and handled by defense attorneys, prosecutors, and the court staff and pretrial services.
Okay, I'm going to squeeze in a couple. We didn't get to information sharing. I just want to point that out, that there is a law on the books in the Health and Safety Code that says everyone but the prosecutor must share information, must receive information and disclose information if it's in the continuity of care. This isn't the right slide for it, but that's on information sharing. Okay, so for this giant chart right here, it shows all the things that you can do with the 1622 report. It's basically mapping out the law. And one we didn't get to talk about is the one on the far right. And again, not very many people know about this, but I think we're trying to build that knowledge, is that if you have a defendant with a non-bodily injury offense, that they can be transferred to outpatient mental health services with or without dismissing the charges. So the charges could be left pending, they could be dismissed as part of it, but Texas law left that flexibility in there for the criminal side, but they transfer it over to the court with probate jurisdiction into an outpatient services. And if you don't have that, obviously that's not going to help, but Bexar County does. And so I know that is going on here, but a lot of people still don't know about that one. So that's what I would add.
I just want to second what Renee said. Here in Bexar County, we are very fortunate, and of course for Judge Huff, she is always trying to educate the public in what our county does, and is moving forward into helping these individuals get the treatment and the help that they need.
Christy said about that one right there, that we do that. I do that. I'll say, even if it's a criminal trespass, I'll let you out, but I want you to be transported over to Cross Point. Like, they're homeless. They have substance abuse. They have mental health illness. So I'll let you out on this teeny little misdemeanor B case, but you have to go over to, and we have a SPU unit that will transport them over to this place. And I use that a lot. And when getting people out of jail, because I know they need the help, and I know that they can just easily do a 2-day jail sanction, which is they're in jail for 2 days, judgment satisfied, they're out, they're back on the corner. But I can also use that law to send them somewhere to get help. You know, I really can, and it's just a little misdemeanor. So, all right. So, any other questions? I think we're with about 3 minutes left. Well, I said yes because I don't, the way the law is written to me, that we had a great discussion about this. Remember, Chris, about does it violate HIPAA? And can we share this? Because I am, in my court, I'll tell the defense attorney, here is the report. Do you want to read it? Because the way they actually carved out an exception in the law so that it won't violate HIPAA. Right? And so I'm saying that, say, like if you called up to the court and say, do I have a 1622 or does my daughter have one? I guess. I don't know if we could say yes or no. I don't know if we're walking the line. What do you think, Christy? Could I answer her? Could a clerk say to her, if she's calling to say, does my daughter have a 1622 report done? Or versus what does the report say? Like, could the court say, yeah, what is done, but I can't tell you what it says? What do you think, the law? Because sometimes it's nuanced.
I think that's an unknown at this point, and it probably depends on the culture of the office.
Oh, now the defendant can definitely be told because I'll give them that report. They're standing before me. They definitely can be. It's them. So I'll open it up and I'll say, "This is your." And they're always so interested because when they get arrested, and there's so much going on. They don't remember doing this report. And I'll say to them, "Your report is right here in the file. Here's a copy." And they'll say, "I want to read that." And then the defense attorneys sometimes they care, sometimes they don't care. But I can tell you that defendant really wants to see that one-page report of themselves that they have given the answers to. That report is generated off of their answers, right? So no, they can definitely be told that yes, and they absolutely have the right to see that report of themselves. Yeah, I mean, sometimes when they're right before me, standing before me, and that report is in their file, I'll say to them, there is a 1622 report in this file. And then if they say they want to see it, I'll let them see it. It's their report. That's me. I don't know what the other judges do, but I do let them see it. It's their report.
And also there is, on the Odyssey public portal, there is a 1622 that was ordered and completed. It does show that in their record on the portal.
So like this, all the defense attorneys, like if you guys know the defense attorneys of yourselves or loved ones, you can just ask that defense attorney, look in your discovery. They're giving that report is given to them. It is in their discovery. It is just a one page. And sometimes they see it and sometimes they don't, but make them aware of it. Can you see if my loved one has a 16? I guarantee you in Bexar County they do. The defense attorney may not have been looking through it or saw it. It is there. It goes to them. It goes to the prosecutor, it goes to the defense. Every last defense attorney that's court appointed or retained, that discovery is sent to them, and that 1620 report is in that discovery. I guarantee you it is there. And we fine-tune this. If they're saying, oh, that's no such thing, I've never seen it, then go back and check it. It is there. I guarantee you it is there. No, they cannot because this is law. This is mandate. This has to be done. Like all the counties are ordered to do this. So it's not like they can say, "I want this out of my file." It's to aid all these stakeholders and how they're going to treat that defendant and how they're going to, should I say, treat, yes, and defend the defense attorney. How the judge is going to deal with it. How probation is going to deal with it. It's an aid in how to help and how we're dealing with this person who's just been arrested. And sometimes they'll get rearrested and their report has already been made, right? And so we don't have to do another report if it's a year, but it's all geared towards the court system helping the public in dealing with individuals who are coming into the judiciary with mental health illnesses. I saw one question over here. Yeah, MAC program, they sure do. I have some here today. Lori Jose here. Where's Lori? I know she was here earlier. Yeah, they work with me. And that's I'll tell Jim Bethy, he's the director, he'll be glad to hear that. They're very new, so the MAC is a managed assigned counsel, and it's something new that the Bexar County just got grant money for, it's a whole entity created, organization to help and assist defense attorneys, mental health, how they take care of their clients. Some of them are very young, they don't know how to manage or what to do in court. That is what the MAC program does. It's just been getting off the ground. How long, Lord? 2 years? It's very new. It's very new here in Bexar County. But other big cities have. I know Dallas, Lubbock, Houston have those. So I'm happy that I work closely with the MAC. I like them in my court. They come to my court. They shadow the program, and I'm happy that they're here. Okay. Well, thank you guys. You guys have been wonderful all day long. I hope you guys all learned something new about the judiciary and mental health. Like I said, I invite you guys to come to my court, shadow the program, shadow the mental health court, learn for yourself. Come back and take many books that you need, okay? I'm pushing them out to the community, resource books. Thanks again, everyone. Another round for our awesome panel here. Come on up if you have questions, guys.